This is a short introduction to the legal system, provided by the Community Legal Education Association. This presentation is for information purposes only. It is not legal advice. For legal advice, talk to a lawyer. Laws are the official rules of a society that tell people how they can or cannot act. Breaking a law can result in a penalty, such as a fine or imprisonment. Laws can exist on different levels. They may apply to a whole country, a province or state within a country, or an even smaller community, like a city or village. Laws may also apply only to specific industries or apply only in a particular set of circumstances. For example, laws that apply to banks or to the process of holding elections. The main purposes of laws are to provide order in society, to provide a peaceful way to settle disputes, and to express the values and beliefs of a society. Laws may either be statutory or a part of the common law. The basic difference between the two is that statutory laws are laws written by legislators, such as members of parliament, senators, or members of a provincial legislative assembly. The common law is made when judges interpret these laws. Statutory laws are called acts or statutes. These laws start out as bills in Parliament or in a province's legislature. These bills go through a long process of debate and sometimes changes are made. After being debated on, legislators vote on whether the bill should pass. If it passes, it becomes law. Many acts and statutes also contain regulations, which allow the government to work out some of the finer details of the law. Regulations can be changed or amended much more quickly than bills or statutes because they do not need to be debated. Federal regulations can be made by the Prime Minister or their cabinet, and provincial regulations can be made by the Premier or their cabinet. There may also be policies to consider. Policies are not really law in themselves. They are more like the rules that explain how certain aspects of the law will be carried out. Policies are usually made by administrators or officials within an organization. Here is an example to show how statutes, regulations, and policies work together on the same topic. The Employment Standards Code is a statute that governs many aspects of employment in Manitoba, including wages. The code says that you must be paid at least minimum wage for your work and sets out a formula for determining minimum wage. It also says that an employer must pay an employee at least twice a month and within a certain time frame of the work period. The code also sets out some specific exceptions to these general rules. In the regulations to the Employment Standards Code, there are some additional laws about wages. For example, the regulations set out certain types of jobs that have a different minimum wage and explain what that minimum wage is. The regulations also set restrictions on what type of deductions an employer can take from your wages. Workplace policies would handle matters like your wage amount, the frequency of your paydays, and the actual day of the week your wages are paid. However, keep in mind that these policies are still subject to the statute and the regulations. For example, a workplace policy could say that you will get paid more often than twice a month, but it could not say that you would only be paid once a month, because this would go against the statutory requirement to be paid at least twice a month. The most important statutory law in Canada is the Constitution. The Constitution is the supreme law of Canada, and any other laws that are not consistent with the Constitution are considered invalid. The Constitution is not one statute, but a group of several statutes. The Constitution Act 1867 is the act that created Canada as a nation and set out its government structure and the powers of the provincial and federal governments. The Constitution Act 1982 contains the Canadian Charter of Rights and Freedoms, which sets out fundamental freedoms and other important rights. The Constitution Act 1982 also affirms the rights of Canada's Indigenous peoples. Another important statute is the Criminal Code of Canada, which sets out criminal offenses throughout the entire country. Common law is law that is made by judges in court decisions. Judges cannot create new laws on their own, but they often need to interpret what a statute means when a case comes before them. When they do this, the decisions they make can clarify what the law means and how it should be applied. They can also interpret the previous rulings of other judges. Judges also have the power to declare a law unconstitutional. This happens when a law is not consistent with the Constitution. In these cases, a judge will often declare that the inconsistent part of the law is of no force and effect. This means that it is not valid law anymore. It is important to remember that because of the long process involved with changing a statute, parts of the law that judges have declared invalid might still appear in the text of a statute. This is the basic structure of the Canadian court system. There are special branches of the court system that deal with military matters, taxes, and specific federal matters, such as intellectual property, immigration, and national security. These branches are shown here in green, yellow, and blue. The most common court process, which we will look at more closely, is shown in orange. Each province and territory has a provincial or territorial court, a superior court, and a court of appeal. The only exception is Nunavut, which has a combined territorial and superior court. Each province or territory may also have several administrative tribunals, which have the power to make decisions on certain specific types of matters, such as tenancy or human rights. These tribunals and courts appeal to the superior court for the province or territory. The superior court appeals to the Court of Appeal for the province or territory, which can appeal to the Supreme Court of Canada. Trials in provincial and superior courts are heard by one judge, or in some cases in superior court, a judge and jury. Appeals at the Court of Appeal or Supreme Court are heard by a panel of justices. If the justices decide differently from one another, the majority's opinion will become the decision of the court. An appeal is a request for a higher court to review a decision made by a lower court. A request for an appeal can only be made after the judge hearing the case has made a final decision. If either of the parties involved in the dispute feel that the judge decided wrongly, they can request to have an appeal heard. There are two types of appeals. Most of the time, a higher court has to give permission to allow an appeal from a lower court to be heard. This is called an appeal by leave of the court. In some rare cases, this permission is not needed. This is called an appeal as of right. For example, if a case appears in a provincial court of appeal and one of the justices disagrees with the others on a point of law, the Supreme Court must hear the appeal if requested. An appeal is not just a chance to have another trial if one party is unhappy with the result. There must be a valid reason for reviewing the lower court's decision. Some common reasons include the judge making an error about the facts in the case, the judge making an error about the law, the appearance of bias in the trial, for example, bias from the judge or jury members, and incompetent counsel, meaning the lawyer failed to properly represent their client. A court does not need to hear every appeal that is requested. If they feel there is no valid reason to review the decision, they can deny leave, meaning they will not hear the appeal and the lower court's decision will remain in effect. There are also many procedural rules concerning appeals, and a court may reject a request for an appeal if these rules are not met. If a court does decide to take an appeal, it will review materials submitted by both parties explaining why they think the lower court's ruling should or should not stay in effect. There may be an oral hearing at which lawyers for each side will make their case and answer questions from the justices. An appeal hearing is similar to a trial, except there are no witnesses and the lawyers must limit their argument to the grounds of appeal. After arguments have been made, the court will make a decision to uphold the lower court's decision, reverse the lower court's decision, or send the matter back to the lower court for a new trial. Here is a closer look at Manitoba's court system. The lowest level of court is the Provincial Court of Manitoba. This is where trials are held for most criminal matters. It is also where provincial offenses such as traffic tickets appear. The Provincial Court has some jurisdiction over child protection matters and matters under the Family Maintenance Act, such as spousal support. It also presides over inquests under the Law Enforcement Review Act and the Fatality Inquiries Act. Matters in provincial court are heard by a judge, or in some cases a justice of the peace. The next level of court is the Superior Court, which in Manitoba is called the Court of Queen's Bench. In Manitoba, Queen's Bench is divided into a family division and a general division. There is also a small claims court, where court officers can hear civil claims up to $15,000. The family division deals with all family and child protection matters. The general division hears trials for civil matters over $15,000 and certain serious criminal matters. Some serious offenses, like murder, must be tried in Queen's Bench instead of provincial court. Matters in Queen's Bench may be heard by a judge or, in some cases, a judge and jury. Some matters in the family division may be heard by a master. The general division also functions as an appeals court. It can hear appeals from small claims court, administrative tribunals, and trials held in provincial court. Appeals from the Court of Queen's Bench go to the Manitoba Court of Appeal. The Court of Appeal only hears appeals. It does not hold any trials of its own. Both the Family and General Division of Queen's Bench appeal to the Court of Appeal. Hearings at the Court of Appeal are heard by a panel of justices, usually 3. Cases decided by the Court of Appeal may be appealed to the Supreme Court of Canada. Remember, in order to have your case heard by the Supreme Court must either give you leave to appeal or you must have the right to appeal. Cases at the Supreme Court will be heard by a panel of 5 to 9 justices. The Supreme Court is the highest appeals court in Canada, meaning a case cannot be appealed any further once the Supreme Court has made a ruling. When making decisions about cases, judges are expected to follow the precedents set by other cases. A precedent means a previous decision that should be used as a guide. The idea behind precedent is to make sure the law is being applied consistently. There are 2 types of precedent, binding and persuasive. Binding precedent means the court must follow a precedent and interpret the law in the same way another court has. A decision of a court is always binding on any courts below it in the same branch of the court system. For example, the Manitoba Provincial Court must follow the decisions made by Manitoba Queen's Bench and the Manitoba Court of Appeal. Since the Supreme Court is the highest court in Canada, all of its decisions are binding on every court in the country. Persuasive precedent means the court can look to other courts to see how they have interpreted the law, but they do not necessarily need to decide in the same way. For example, any Manitoba court can look to the decisions made by any other province's courts, but they do not have to decide in the same way. The higher the level of court is, the more persuasive it will be. For example, decisions from the Saskatchewan Court of Appeal are more persuasive than decisions from the Saskatchewan Provincial Court. In some cases, a judge may decide to overturn an existing precedent. This does not happen very often, but it may be reasonable in certain circumstances. For example, if a certain topic has not been addressed by the court in a long time and attitudes toward the topic have changed over the years, a court may decide in a way that ignores the ruling in the earlier decision. For more information about the legal system, visit CLIA's website at communitylegal.mb.ca. For the Law Phone-In and Lawyer Referral Program, call 204-943-2305 if you are in Winnipeg, and 1-800-262-8800 for toll-free service outside of Winnipeg.